attorney at Koch and Hoffman, PA, with offices located in Clearwater and Tampa, Florida. Along with all areas of family law, our firm handles the drafting of prenuptial and postnuptial agreements. I've spoken previously on an overview of postnuptial agreements and what they serve to protect. Today I'm going to go into a little more detail as to how postnuptial agreements operate. The postnuptial agreement is based on the presumption that both parties have fully disclosed their financial affairs without holding back any information. Full financial disclosure is a major component of the validity of a postnuptial agreement. In case it later emerges that one of the parties was holding back on his or her true financial status, a Florida judge might hold that the agreement was in bad faith and therefore invalid. It is in each party's own best interest to make a full and final disclosure of all their assets and liabilities. This benefits both sides during the negotiation and drafting of the postnuptial agreement. Though the Florida statutes hold that as long as the assets are actually disclosed, the exact value of the asset doesn't matter, in practice, the family court judge might in fact decide that the other party wasn't informed of the assets at all and hold the agreement invalid because of that. The postnuptial agreement should cite the consideration for it. In the case of prenuptial agreements, it is understood that the proposed marriage is the consideration. However, postnuptial agreements should clearly state some type of additional consideration since the marriage has already occurred. A postnuptial agreement should also clearly set out the reason and purpose for it. Perhaps the reason is because the parties feel a divorce is imminent and they want a document spelling out certain financial rights in advance of filing for a divorce. Or perhaps the reason is because the parties do not plan to divorce, but are simply going through a rough patch and have had some disagreement as to certain financial responsibilities, and they want a document memorializing a final agreement between the two of them. While it may seem counterintuitive, postnuptial agreements can in fact serve as a source of comfort for both parties who might simply want some clarification on marital and non-marital assets. If the document is also meant to enforce the waiving of the claim of one party to the other party's assets, businesses, retirement plans, or immovable property, the agreement should explicitly mention that the first party knowingly waives his or her rights to the other party's assets, businesses, and retirement plans after being apprised of their values. If the postnuptial agreement includes an alimony waiver, it should clearly and explicitly state which type of alimony is being waived: permanent, rehabilitative, durational, lump sum, or bridge the gap. In Florida, temporary alimony cannot be waived, and if there is an attempted waiver of temporary alimony in a postnuptial agreement, it will not be upheld. Lastly, postnuptial agreements should always be prepared by knowledgeable and experienced family law attorneys. It's so important that these documents are properly witnessed by two witnesses and safely held with the legal representative of the parties. Thank you.